Okay, I'm going to call this meeting to order. This is the Nottingham Planning Board, Wednesday, July 14th, 2021. I'm going to just ask the roll call around the room. Buzz, if you could start that off.
Robert Davies, alternate.
Gary Anderson.
John Moore, Selectman Rep.
Edward Veal. Dirk Grotenhuis.
Susan Mooney.
Ian McKinnon.
Jancis, SRPC.
Thanks, and welcome to John Moran. He's now sitting as the Board of Selectmen's representative. He's served on the board in the past and is a valuable member, so welcome back.
Thank you.
I also want to seat Robert Davies for Charlene Anderson. Charlene's a board member and is not in attendance tonight, so you will act as a full voting member. And I just want to just quickly step through a couple of items here. We do have a bit of a larger crowd. There is a second room that is conference room number 1 down the hall that has a videotape, video and audio setup of what's happening in this room. So if anybody would like to have more room or space, there's that room you'll be able to hear. And then if you would like to come and speak, there was for a public hearing, you'll be able to do that. You can come back to this room. When we do get some larger crowds, I just want to go through just a couple of ground rules during the meetings. Please be respectful of the applicant or anybody else who's speaking. Please have full attention. If you need to have a conversation amongst yourselves, please remove yourself from the room. Just try not to be a distraction to the proceedings. And please turn off any electronic devices that may make noises and distract people. And we'll have during the public hearings, we'll have the public will have opportunity to come up and speak. I just want to make sure that we'll have respect and be not only respectful of the applicant, but the board members here as well. The public meetings are intended for the board to get information of the public. So anything that the public has in comments, please direct them to me, the chairman, and not have any other discussions with anybody else directly with the applicant or anyone else. And then I'll just get your answer resolved or answered. Your question answered. So with that, we do have 3 cases tonight, and I will just run through those and tell you what they are quickly. We do have a lot line adjustment as the first one. That's a continued case, and that's 21009 LLA. We have the second item is another lot line adjustment. This is a new application. And this one's 21010. And then there's a continued case for site plan application, and that's 21003. So those are the 3 that are on the agenda. So as I said, please be respectful when others are presenting. Anything from the board before we get going into these hearings? So the first one will be the continued case, 21009 LLA. The application is for a lot line adjustment from Gail Bateman, administrator of the estate of John F. Bateman, and Alan Marcia Putnam, represented by T.F. Moran, Seacoast Division. The property is located at 10, 12, and 14A Barrington Road in Nottingham, identified as tax map 1, lots 2, 3, and 4. We have accepted this application and had requested some additional information, and this went to the ZBA for variance. Variance was granted, and it's now back to the planning board for the lot line adjustment. So with that, if the applicant is here, please come to the table. Just give us an update of when that was left off, and just a...
Good evening, Mr. Chairman. Mo Vanderpool with TF Moran on behalf of the Bateman Estate. I do have 2 color exhibits, if I could pass those out.
Sure. Great.
Would it be okay to read through my introduction, sir?
Yes, please.
Okay. Good evening, Mr. Chairman, members of the board, and members of the public. I am Marinus Vanderpool with TF Moran, Civil Engineers and Surveyors. On behalf of our client, Gail Bateman, Administrator of the estate of John F. Bateman Jr., and Alan and Marsha Putnam, owners of the property at 14A Barrington Road, we are here with an application for a lot line adjustment between the 2 adjoining properties. These abutting properties are located in the northeasterly section of town on the north side of Barrington Road, also known as Routes 9 and 202, across the road from North River Pond. The properties fall within the residential agricultural zoning district. The purpose of the lot line adjustment is to resolve a current encroachment of the house shown as number 12 Barrington Road and related improvements as shown on the lot line adjustment plan. The encroachments consist of a small portion of the dwelling and shed, as well as the septic cover, deck, and retaining wall. The lot line adjustment will increase the total frontage of the Bateman estate from 200 feet to 225 feet, and will reduce the frontage of the Putnam property from 200 feet to 175 feet. On May 18th, 2021, the Nottingham Zoning Board of Adjustment granted a variance from Article 2, Section C, 2B of the zoning ordinance to allow for this reduction in frontage. The proposed lot line adjustment would also bring the house at number 12 Barrington Road into compliance with the required side yard setback of 20 feet. The abutting Bateman and Putnam lots are both pre-existing non-conforming lots of record. The proposed lot line adjustment is an equal exchange of land. That is 2,111 square feet of land from each lot to the other to maintain the original amount of square footage upon each lot. That is, the proposed lot line adjustment will not result in either lot losing its original amount of square footage. We are requesting 2 waivers. Can I read those off now, sir?
Sure, please.
Waiver request number 1 from Article 8.3, subsection 6, plan requirements. Existing grade and topographic contours at intervals not exceeding 2 feet with spot elevations where the grade is less than 5%. Because there are no proposed improvements to either property, we feel that showing topography is not necessary. The second waiver is from Article 14.2.2, subsection 7, for lot shape. Sidelines of lots shall generally be at right angles to straight streets and radial to curved streets. The proposed sideline between map 1 lots 2 and 3 and map 1 lot 4 are moderately less conforming to this regulation. The purpose of the proposed lot line adjustment is to correct existing encroachments. Therefore, we feel that a waiver from this section is reasonable. In summary, we are here tonight with a proposed lot line adjustment in an attempt to resolve an encroachment issue. On May 18th, the Nottingham Zoning Board of Adjustment granted a variance to reduce the frontage from the Putnam property and is an equal exchange of land. Until the encroachment problem is resolved, both properties are unmarketable. The Bateman property is currently listed for sale to pay back taxes to the town, but no closing can occur until the encroachment problem is resolved by a lot line adjustment. We respectfully ask for the board's approval of the proposed lot line adjustment. We appreciate your time and attention, and I'd be happy to answer any questions you may have.
Thanks. Could you step through these color plans that you've passed out, please?
Absolutely. The first one is exhibit tracts comprising the land owned by the Bateman Estate on the north side of Barrington Road. This is to show,
Is that this one, the aerial one?
I'm sorry, that is this one here.
Okay.
This is to show that the remaining land of the Bateman Estate is comprised of 3 deeded tracts in the conveying deed of record, which I have a copy if the board would like to view. And the color up is just to show the relationship of those to each other. It is noted that at the last hearing, there was a question as to notification of the town of Northwood as an abutter, which has been done. And a small portion of the Bateman property does lie within the town of Northwood. Yeah, but from comment on the other exhibit, Mr. Chairman, from the last hearing, there was a request made to show an exhibit to show the relationship of the assessor's parcels in relation to the surveyed lines, as the assessor's lines for the town of Nottingham and the assessor's lines for the town of Northwood don't match up very well. The information for the assessor's lines was taken from UNH Granite. That's a GIS database system. So on this plan, the dark blue lines represent the surveyed lines of the Bateman property and the Putnam's property. The dark orange, or sorry, light orange lines represent the town of Nottingham assessors parcels. The lighter blue lines represent the town of Northwood assessors parcels. And the purple double short dash line represents the town and county lines. The question at the last meeting was if Northwood map 22, map 232, sorry, lot 22 was notified. This is to show that that lot is not an abutter. The direct abutter to the Bateman property on the west is Nottingham, map 1, lot 1, and that is shown in the red dash lines. The small triangle in the light purple is the portion of that lot that lies in Northwood. Northwood took that piece for tax purposes, and Northwood has been notified. Nottingham has taken the remainder of map 1, lot 1 for tax purposes.
Can we just go back to the other color plan with the red, blue, and green?
Yes.
That you're indicating is the, I guess, what are you indicating those are, if you can repeat that?
So those are 3 deeded tracts that comprise what Nottingham's map 1 lots 2 and 3. Those are the lines by deeds.
Okay, so the deeds have this outline. That,
3 tracts, correct.
but is that one lot?
It is one piece of land that consists of 3 tracts of land. Nottingham has been assessing it as 2 lots, number 10 and number 12. The tax, the assessor's line on the tax map between map 1, lots 2 and 3, i.e. number 10 and number 12 Barrington Road of the Bateman Estate, does not correspond with any of the deeded lines.
I guess my question is that would 10 and 12 be on the same lot?
10 and 12 are on the same tract. That's tract 3 of the parent deed.
So there's two houses on the same lot.
Correct. However, that lot, as shown, it does not correspond with the Nottingham tax maps.
We trust surveyors more than we trust tax.
Thank you, Mr. Chairman.
I don't get this top lot though. So that on this plan that you presented, so you have that top tract,
Yes,
but that doesn't appear to be reflected as a surveyed line on like the aerial view.
yes, the blue lines, the dark blue.
Yeah,
The blue and the purple line create it, but it's there's the overlapping orange.
that's all inclusive.
Yeah, see the barn here?
Yeah, okay.
It's this piece, is this piece.
So these aren't the surveyed lines on this one. These are kind of more mapped up with
The outside extent of those 3 colored portions are the surveyed lines.
The orange and the light blue are the GIS, and obviously they're
Okay, I see it,
shifted by about 100 feet. Dirk, while we're talking about plans with color, and is that something you put together? Or what is this related
That
to?
was our conversation.
Okay.
Yesterday, yeah.
That's what I was wondering. I saw it there, so I printed it. I wasn't sure what it was.
It's a worksheet,
Okay.
right, Jen?
Just scribbling thoughts down,
Okay.
trying to convey pictorially.
Gotcha.
go over additional.
Yeah, I wanted to just, Jen, do you want me to read through these, or are you prepared to just maybe highlight the ones that SRPC brought up?
Sure.
Okay.
Sure. So kind of going into it, I think the biggest concern is just cleaning up the uncertainty as to tract 1, 2, 3 versus parcels 2 and 3. I think that was the biggest concern that we had talked about, and that is the sketch that you were just referring to, Ian. And looking at where we don't know where the actual, well, we've got the deed, we've got that.
Correct.
And it doesn't create, well,
The tax maps and lots,
yeah, it
correct.
doesn't correspond to the tax maps. It creates something that's, again, still less than marketable, where you've got buildings that traverse those different tract lines. In terms of were those to ever be conveyed in the future, you've got the tract at the back that has absolutely no frontage. You've got the tiny little tract 1, and then tract, is it 2 on the front that has, sorry,
In the front, you
tract
have-
3 is in the front.
Correct.
Tract 3 in the front has the 2 houses. So were they ever to be conveyed separately, it would need to be rectified as well. The barn is, the barn overlays all 3 tracts. It doesn't lay entirely within any one of them. So that was one of the conversations, and taking this as an opportunity where there is definitely some conflict between what is in the town's assessing records versus the deeds. Good opportunity to clean that up. So that was one of the things that was the main thing that we wanted to kind of put forward as a point of discussion. We didn't have any objections on the waivers, and I believe on the notes, we just want to make sure that the variance was not the date of approval, but of the variance, so we want to make sure that that gets updated on the plans. But otherwise, I didn't really have any substantial comments.
Okay, thank you.
The date of granting, it has been added to the plan,
Okay.
as well as the abutters have been updated.
Thank you. Do you have comments from the board? Questions for the applicant?
Yeah, I have some questions, and I don't know if they're germane to a lot line adjustment, so I'll throw them out there, and then we can always, decide what, if any. So going back to the town tax maps, which is funny, this copy tonight, you can see where there's a measurement for a lot across the street. You can't really read it, but you can see that it's there. So tax map 1, lot 12, shows that it's actually tied to map 1, lots 2 and 3. So it wouldn't be a separate, even though it's got the road going between them, it's tied, it's like, to me, is one lot. So I don't know if that should be shown on the plan, and measured, or a note mentioned that we're not creating a separate lot over here. That nothing we're doing is creating that as like a separate buildable lot. So that was one question. And then, I know the intent of this is to clean up the encroachment that was unintentional. But at the same time, it looks like the shared driveway that's over on map lot 1, lot 4, it's not even on map 1, lot 4. The curb cut is actually on the
It
next
does
lot
cross.
down.
Yes, it does cross.
And the easement doesn't mention that it's coming from
The easement for
the driveway for lot 1, 4,
4A
and then
in the rear.
and then behind that, it doesn't mention that it's actually coming from lot 1-5. It's reading as if it's coming from lot 1-4.
The easement is from lot 4, however, there is an encroachment.
Yeah, so I didn't know if that was, if this would be a good time to try to get that cleaned up too, or if we can continue to move forward, knowing that this driveway, this lot 1, map 1, lot 4, doesn't actually have a curb cut going to it currently. And then the gravel path that's shown on lot 1, 2, and 3, map 1, lot 2 and 3, didn't know if that's actually a driveway, another shared driveway or easement that's going through, or if that's just kind of shown for purposes here of.
There was no easements found related to that gravel driveway.
That dirt gravel path that's labeled, okay.
Correct.
Looks like it just provides access to that barn and that piece of property in Northwood.
Right.
And then just to confirm, because we've run into this before, we've seen things labeled as existing buildings. Can we just confirm that the existing buildings, big number 10, number 12 are actually dwellings, and number 14, those are the dwellings? There's no other.
12 at this time was recently occupied as of about a month or so ago. It has been unoccupied to the best of my knowledge. Number 10 was deemed uninhabitable. So there's been no occupation of that house. I do not know the length of the time.
Okay. Any other comments?
No, those are kind of the big things I had was the curb cut, this one.
Anybody else have comments? Yeah, go ahead, Ian.
To build off the worksheet, the discussion sheet, so there was discussion about the 3 lots, which I think makes sense because technically, even though one of them's
Legally.
not legally, there's different dwellings. Is that something that you think will happen, or will that require, or,
The estate
Deci-
plans on selling these 3 tracts as one piece.
okay, so
They do not.
the intent is still to keep it the way we've seen on the plans, and there would be
Yes, sir.
2 dwellings on that lot, 2 and 3. Okay.
And really the reason behind this was to get the setback, right?
The primary reason for the lot line adjustment is to bring the dwelling number 12 completely on the Bateman property so that it can be sold. In its current state, neither properties are marketable in the current condition. As well as to pay the town the back taxes.
For me, it really brings up the question of that map 1 lot 12, where the assessing cards showed that tied to 2 and 3, and 2 and 3 tied together. You know, it's not referenced at all on here that kind of, to me, and my assessing knowledge is minimal, so I'll throw that out there, but I want to make sure that we're not, by not referencing it and not having it on here, any kind of note on it, that we're not creating some new lot by itself that's.
It is a separate parcel by the deed. They could sell that separately. I don't know their intentions, but
They could or couldn't sell it?
Could.
This one across the street?
Yeah.
I think it's just the same owner.
It's got a tie line on it though, so,
the tie line is only to a monument, to a property monument.
okay.
That's something we do. So in the future, if another surveyor was to come out to try and put the lines back on the ground, it's a tie from one of the monuments on the Locust property to another monument remotely to assist another surveyor with putting the lines back on the ground.
But on
It's
the-
not a legal tie, sir.
But on the assessing maps show tie lines.
That tie line is just common ownership.
Okay.
All right, I'd like to open it up to the public hearing. And we can deliberate after that. If you wouldn't mind making a little bit of space, if there is some public that would like to come up, we would want to hear them through the microphone. I'll first open it up to anybody that would like to speak in favor of this application. Feel free to come up, just state your name and make your comments. So anybody in favor, and then anybody opposed? Anybody with just a comment?
Actually, I know the Batemans, I know good people. And they're trying to sell.
Yes.
Are they moving to Florida?
I can't
I know
answer
that years
that.
ago they were thinking about it, so. I've known the family a really long time. I know one of the son passed away quite a few years ago. That was a really sad thing. Our sons used to go to school together in Nottingham. So it was kind of like weird that I heard the last name. I was like, oh, I know them.
Can we just get your name?
Jennifer Dubois.
Thanks. Any other comments? Great, thanks. I'll close the public hearing, bring it back to the board for motion for action.
Do you want to take care of the waivers right now?
Good point. Yes. I would like to have a motion to approve the waivers as noted in
I'm happy to read that.
our notes. Yeah, if you want to just read that.
Do you mind if I bunch them together, or do you want me to separate them?
Add them together.
Okay. I'll make a motion to approve the waiver requests, specifically to Article 8.3 subsection 6, plan requirements foregoing the depiction of topography, and Article 14.2.2 subsection 7, lot shape, right-angled property lines.
I'll second that.
Motion and a second. Grant those waivers. Any other discussion? Those in favor indicate aye.
Aye.
Those opposed? It's unanimous for the waivers.
Since we don't miss it, Mr. Chairman, I move that this does not have a regional impact.
I'll second that.
Motion and a second on regional impact. Any discussion? Seeing none. Those, in favor indicate aye.
Aye.
Those opposed? That's unanimous as well. Not sure we need any more line adjustments, but
Oh, that's not here, so I just.
Just to bring it back to the board, any other further discussion and/or motion?
Mr. Chairman, I just have to say that our task in front of us today is pretty straightforward, even though the applicant has a lot more work to do down the road. This will give him the opportunity to do so.
We're ready to vote on this?
I think so.
Mr. Chairman, I move that we approve case number 21-009 LLA, the application for a lot line adjustment from Gail Bateman, et cetera, including the 2 waivers that we had voted for as well.
Second.
Motion and a second. Discussion.
Just to make sure the conditions are reflected. They're minimal, but it's the standard conditions of,
With standard conditions.
With standard conditions.
I think you have a copy of the conditions from SRPC.
Yes.
Those in favor indicate aye.
Aye.
Those that are opposed? It's unanimous.
Thank you, Mr. Chairman.
Thank you.
And this is very helpful, so thank you for that.
Absolutely. Procedurally, we address the conditions of approval and submit, in this case, to Dale, the Mylar and the town records. Is that correct?
Yep.
Very
We'll
good.
we'll have to have the planning board sign them.
Correct.
I would like to note one more thing. If you could add, we do have a standard signature block for the planning board. If you could add that to this plan. Right now, there's just a single chairman line to approve it.
Okay. Is there a pictograph of that?
Yeah, I
And
think it's
it-
in our subdivision regulation or site plan regulation, but it's basically a line with, I think it's 6 lines, 7 lines.
Very good. Yes, sir.
Just like that.
Will do. Thank you, Mr. Chairman.
Yep, thank you. All right, and to the folks that did come in during that presentation, just to let you know, there is another room, conference room 1, that has audio and visual. So if you are interested in just watching this, and if we get to a public hearing that you're interested in speaking, you can come back into the room. There's plenty of room there.
Mr. Chairman, it's conference room 2.
Are we in one?
We're in.
Just send him in circles.
Let the minutes reflect it as conference room 2. Thank you for that clarification, Secretary. All right, next on the agenda is case number 21-010-LLA, an application for lot line adjustment from Mark C. and Patrick A. and Patricia A. Wasson, 70-25 LLC. The property is located at Lamprey Drive in Nottingham, identified as tax map 70, lots 23 and 25. The applicant's here, and they can...
Yes, present. My name is Mark Wasson. Thank you, Chairman of the Board. We've submitted an application for a lot line adjustment.
Great.
I'm here with Mr. Peter Landry, who's done the survey and the documentation.
Going through the completeness review, it does appear that everything is complete, so we will have to make a motion to accept this application.
Mr. Chairman, I move that we accept the application for case 21-010-LLA as complete.
Second?
In a second, any other discussions? Those in favor indicate aye.
Aye.
Opposed? That's unanimous. We can now, that it's been accepted, we can review this application in more detail and have discussions with the applicant the applicant's agent. And in this case, there are a couple of waivers, one waiver?
Waiver.
One waiver. And we would like to hear maybe from the applicant, agent on some specifics of what this lot line adjustment is accomplishing.
Certainly, thank you, Mr. Chairman. Again, for the record, Peter Landry, Landry Surveying, here in behalf of Mr. Wasson and Mr. Bascom, who's in attendance. Looking at, let's see, a month ago, before the warrant Article 19 was passed, this might have been looked at a little bit differently, somewhat of a straightforward lot line adjustment. The reviewer has come up with a couple of housekeeping things, some signatures on the final plan, some legend stuff, and addressing the waiver. But I think the biggest issue out here today is number 2 on the staff technical comments, which talks about clarification, additional information, and provisions, again, circling around the June 8th, 2021 warrant Article 19, which I have a copy of. And I gotta be honest with you, I could read it, but I don't know if anybody here understands or can explain definitively what was accepted. And that's gonna be a problem. So anyway, Article 19 talks about the town will vote to accept. They list a number of town roads, which were private roads, mainly around the lake. The 3 that pertain to this area, Dolph Dam, Indian Run, and Lamprey. They just list town names. There's no description of where the roads are, how wide they are, or any information. It's pretty blanket. They do put a clause in that says the town has been maintaining these roads for decades. Oh, okay, maybe that's a clue. With the acceptance of these roads will be transferred, something, probably an easement, to the town of Nottingham as a Class 5 road. Okay, so now it's a classification, basically Class 5. Now they're town roads that could be, we can appropriate money to maintain. So it's been classified as a Class 5 road, and this is kind of, I've never seen this before, but as is. I don't know, I've seen that when I've sold cars, but I don't know what it means when they talk about accepting roads. So anyway, that adds to the confusion that I've had, and as much as I would agree with all of these elements that talk about me or somebody, I don't know if it's gotta be me, because I see it this differently, trying to supply. Well, let me back up. What you're looking at now on my plan is all of the record information that I could find pertaining to the roads. Let me explain. Lamprey Drive is shown. It's a 33-foot platted road on a approved plan that's recorded at the registry. There's a comment on that subdivision plan, which was drawn in 1965, that basically says that the leasees or the abutters, the road to be made by leasees so the abutters can get to their lot. That's the description of the road, or what is labeled as Lamprey Drive. So, what I've shown on my plan, and what you have in front of you, is an edge of a traveled way with a label existing travel way to Dolph Road. And I basically refer to that note that's on the subdivision plat that says they're gonna build a road somewhere to get to these lots. Now, big question, and I don't, if I was, if this had happened a year ago and I was asked to do this survey as part of my research and putting this together, I would come to the town. I'd come to the selectman's office, I would come to the road agent, I'd come to somebody who knows more about this than I do, and I'd ask them this question: where's the town right-of-way out here? And I'm hoping they're gonna be able to tell me. because I don't know this. There's not gonna be any more information that I'm gonna be able to present to anybody that's gonna answer that question, because this happened a month ago at a town meeting. So now the question is, and I don't know how you can bring in outside sources to clarify this Article 19. I mean, according to the letters that the select board, when they looked for legal advice on this article, the lawyers for the town suggested they add different language, additional language, so that what's happening tonight on this first application wouldn't happen. But here we are. And nothing got added, nothing got revised. It got put on petition the way it was written, and that's what you see here is Article 19, and I have no idea. So what I'm asking here is, again, and maybe, I'm sure if you sent this out to the lawyers, they're gonna say the same thing. We don't know. What did we do on June 8th? Article 19, what got accepted? Somebody at the town needs to tell us. I can't tell you. So, why is that important? I understood this article to mean that right now the town was maintaining private roads around the lake under emergency vehicle, whatever classification they wanted to do it, but only a portion of Lamprey was actually being maintained, okay? The section of Lamprey Drive shown on my plan that bisects the two pieces and is actually a private easement to a butter dwelling number 24, and I believe a butter Bernard down the road. So they have private rights to use that, and that's what's existing. Now, if this Article 19, I mean, if the intent was to just collect or classify Class 5s for the roads that were just maintaining, then that would not have included this piece, to my knowledge. And that's something that would have to be clarified with the town. Again, I'd have to go to the road agent. What portion of Lamprey are you maintaining if the intent of Article 19 was to just make the roads that are being maintained, because they put that clause in here, Class 5? And if that's the case, then Lamprey Drive, as it's shown on my plan, is still private. And therefore, this lot line adjustment, I would say, in my opinion, would be able to proceed. Would take care of some of the housekeeping items that the planner had come up with. But if the other alternative, if Lamprey Drive, this section of it and every bit of it, even the undeveloped parts of it, are now a town road, well, now we're looking at a subdivision here, and I'd have to withdraw this application because you guys can't approve a half-acre lot. Okay? So, of course, we wouldn't have drawn it this way either. I wouldn't come here with a lot that's non-conforming. But once you draw Lamprey, you tell me if the town can tell me, based on Article 19, that that's now a town road, well, we couldn't put this in front of you because we don't have enough land. And then, number one, and number two, we wouldn't even be doing the lot line adjustment. The whole purpose of this is to take this small, non-conforming lot, a little under a half an acre on the lake, and with the opportunity to buy a little backland, very common around the lakes. This is what we're trying to do to improve the size of this lot, put a little buffer around here, a little privacy. But now with this town road going through the middle of it, that just throws this whole, you couldn't do this. You guys, this board could not approve that. So being asked to provide the town with more information on the roads, you've got everything on this plan that I've got. There's nothing else I could provide you. I guess I could get you copies from the registry, but you could get those too. You probably, according to the lawyer's letter, he sent all of that to the select board. Everything that had to do with the court case, I know nothing about it except what's on the website, but there's a bunch of information plans and such that was sent to the board as to help them make a decision on this warrant article, which again, I don't know what happened. None of that information was actually, none of that input that I could tell had any effect on that article. So, today, unless the board definitively knows, maybe the select board knows, maybe they can, again, as a surveyor, I would have to come to the town, and the town tells me if that's a town road or not. And when you do that, then I'll know what to do. But if you don't do that, and it's left in limbo, then we can't do anything. So the town needs to tell me what's going on out here. What happened on what happened on June 8th of this year?
So let me get in, sorry to interrupt you.
That's all right, that's pretty much it. You know, I don't think there's any need to go further until we get that issue resolved.
Okay, and I'm not going to disagree with you, I just need some information
Okay.
on this. And what you're indicating as the edge of traveled way, that's basically the physical limits of a road or a trail or something,
That's it, the edge of the traveled way, right, where the tires, wear down a path. It's probably 9 feet wide, it's the gravelled area you would see. It's not the ditches, it's not any shoulders even.
The other lines you're indicating are deeded right-of-way or access easement.
That's right.
33-foot right-of-way,
That's correct.
and that's
Shown on a plat.
shown on a plat. And the limits of the traveled way is outside of that in some areas.
In some areas. Well, as an example, right where we're doing a lot line adjustment, right? And
Yeah, my opinion is we would need some legal advice of where the limit of the road would be to meet warrant Article 19. Either the traveled way, or in this case, there's, a deed, right of way, and it's just the road's not inside that right of way. I do want to bring it back to the board for get comments and input. Go ahead, Ian.
I think that kind of comes back to, and I think kind of knew there was a lot of the roads that were accepted under Article 19 might not have had dedicated, whether it was easements or right-of-ways. But that's where it kind of comes back to Article 15 of the subdivision, saying there shall be adequate provision for safe and suitable access to a Class 5 or better road. That's under Article 15.1, subsection 1, and then subsection 2 is the right-of-ways. No street or highway right-of-way shall be less than 50 feet in width, except when topography or physical conditions make additional development in the future unlikely, in which case the minimum right-of-way shall be 36 feet. It's really the only place that talks about, I know we've really never encountered before this article passed any issues with.
Right. I mean, the path really was, my conversations, has been when an application becomes before the board, that we try and get that to match up with the traveled way, to get whatever right-of-way, if there isn't one, to have that matched up. But I would say that we defer to some legal advice to make sure that that's confirmed.
Why isn't the lot that's being purchased, this small parcel, not 2 acres of land?
you didn't want to buy 2 acres.
Was it not? If I may,
But if it's now a town road, it has to be a 2-acre lot.
Well, then it would make no sense. We're trying to enlarge the existing lot we have, not create a new lot.
Well, again, I'm just,
That's the point. We wouldn't do it.
if I could, the original goal, I, among other property owners, were afforded an opportunity to buffer their land a little, and we acted upon it. It appears a little late since this article. It appears if it had been 2 months ago, there wouldn't be this June article approval. So the goal was just to improve our ability with a potential future of putting a home on this property and having a little more flexibility with sizing of leach field location, and to buffer from unknown future development of the land, I'm saying unknown, and providing. So this whole became a struggle between submitting the application and sitting here.
Yeah, no, that's totally understood, but now that, yeah, the June vote went, the townsfolk want Lamprey Drive as a town road, it now bisects that lot. So you would have basically two lots, one on one side, one on the other.
Maybe.
Should that,
Is that definitive?
No.
Okay.
Sorry.
That's the whole point.
Right. It is a possibility that there will be two lots, one on either side of the road. It's a
We wouldn't,
possibility.
Right.
if that's a town road, we'd have to withdraw this lot line application because we're looking at a subdivision.
Yep.
That's all. That-
And then the curb cut for the driveway might become an issue too, because then, is that a shared driveway where the way that curb cut works? Or is that actually on Lamprey Drive?
it's actually on Lamprey Drive, the adjacent property accesses the corner of it, so it appears to be shared.
And that's just one house lot anyway, it's on a common boundary, so.
Right. I don't think we have
We're not
enough.
creating any
to
driveways,
move
these
forward
are
on this.
existing.
Yeah.
No, if this was considered an easement specifically, and we looked at it from that point of view, would this even be possible then?
You mean a private easement?
Right, if that.
It is a
Lamprey
private- it is a
Drive
private easement.
Strictly an easement.
It is a
not-
private easement, right now.
Well, that's
that-
the question, really.
Well, it is a private, that's a fact.
It's an easement, but is it a road? Yes.
I mean, it's not, well, the question is it a town? Was this part of that Article 19? Somebody's got to tell us.
Mr. Chairman, can I ask Peter a couple of questions? I'm assuming that when you did the lot line adjustment, you included the acreage on these two roads in your increased area. Because
Where I have access way easement area, so if I included that, yeah, that's included in the transfer.
Yes,
Because
yes.
right now, that's owned by Mr. Bassett.
Privately,
Right.
privately. So if the town accepts these roads for maintaining, is it possible that they will classify them as an easement only, much like a power line, just to maintain them? But the ownership still belongs with the property owner? And that's, I
Right.
think, what needs to be clarified.
That would be, that's the norm for all the roads. The town typically doesn't own them in fee, they typically own them in easement. And let's remember that, that warrant article says as is. So whatever it is today is what you got. You get a 50-foot right-of-way,
I
it says
don't-
as is.
I don't understand, from what you just said,
Yeah,
my husband and I own the frontage on Flutter Street and the Flutter
don't
Street
think about
section.
putting a toll booth up or anything. You can't do that, but the presumption of title is that if for some reason Flutter Street is no longer needed for a private way, and you stripped
But I don't,
away, that you wouldn't have a void, that the landowner, and, unless it's a contradiction, owns to the center line.
we don't pay taxes on that.
Well, then I wouldn't tell anyone. Especially in this town.
But to your point, that applies when you have a private way, and this has been voted that it is no longer a
Unless
private
there's
way,
a
right?
contradiction, unless there's a contradiction to that. The presumption.
Correct.
Presumption is the center line. Like when it runs, when the deeds say running by Lamprey, the legal term by is the center line. Now, in this case, it doesn't run to the center line, it actually specifically runs along the edge. So therefore, Mr. Bassett owns the entire road, there's no center line presumption in this case, because there's a contradiction to that.
Right, and partially that's because it was never envisioned as,
Never got sold out.
designed as a town road or anything. It was always envisioned
Well, it
as
was-
easements, private roads.
Yeah, and it was intended to be an easement, and it was held over by the original grantor, Lamprey.
Right, so, and then that's where I think as you indicated, Dirk, that we'll need some additional opinion, because
Yeah,
with the article, it comes back to, and we've had this recently, even, I'm thinking of the Smoke Street and Kennard case, where because of the way the regulation reads, that a 50-foot minimum has to be provided, is that at times an applicant has to look at the opposite right away and sometimes alter their property line, or we've had some proposed easements to be able to provide that. So I think that's where there's some question of, I think there's basically every road on that list is gonna have questions in the future that maybe it'd be a good starting point from an
Would it be
opinion.
possible to propose to the town that you abandon your, the Article 19 part of that road? Saying that we
do you
don't
mean?
want this to be a town road area? We
Well,
want to keep this private for us? and
We
now
might, we might
private
not, but
access?
maybe when the public speaks, somebody in the public might.
And then that way.
I mean, you mean,
You
do I have to
maintain it, you
pay-
take everything.
Well, I mean, let's face it, what it comes down to is, if it's a private road, somebody, the town, if the town's not maintaining that today, then somebody, and probably they, by default, my guess is there haven't been any real houses on there year-round, until less within a year or so. And now somebody down there has to pay to have the driveway plowed. And now they just hit the lottery with this Article 19, it looks like now the town's gonna start plowing my driveway. They're not gonna want, I mean, who decides whether, what portion of Lamprey is, I thought the townspeople said the whole thing. I don't know, is it just what's
When you
maintained?
clarify, don't clarify that as a driveway. That's being inaccurate. That is a road. The driveway is what access off that access.
Private driveway.
You just called it, no, you're calling the whole road a private driveway. That is
That's
not
what I call
correct.
it. That's what I call it.
Well, again, you're incorrect.
Okay, well, then that's what I call it.
Okay,
So,
well, you're gonna address it, be
hold on,
correct.
right
We'll
now,
call it a
is-
private way.
there's too many questions and not enough answers, and we're gonna need the town, town's attorney, we're gonna need counsel to weigh in on this specific application, how it is relative to Article 19, and how that gets applied. Article 19 is obviously too vague to put onto every single application, so we're gonna have to get some more information and some answers.
And the people that probably have the most standing to make some kind of argument about what section is, town and which section is not, would be the people who actually own the land on it, the abutters, as well as the actual current property owner who technically owns that road, or did, and now just possibly had that taken away, or granted to the town by other people. So,
Get it.
I'm not a lawyer, so I don't know for certain, but I would think that those individuals would have the most standing to make a case for it. But as it is now, again, just because this is the first and none of this has been delineated yet or determined, like you said, the warrant article is unfortunately vague. Some of those roads mentioned, I think it mentioned emergency lanes have maintained, and some of them are private roads that were not maintained, so unfortunately it is, we're at where we're at right now.
Yeah, at this point, we're gonna need to continue this.
Ready
until
for
we
a
get more
motion?
information.
Are you ready for a motion to continue unless, did you have anything else to add, or?
There's really nothing else to add until the town can tell us
Okay.
what's a town road out there and what isn't. Once you tell me what is, what got accepted, then I'll know how to modify the plan and then make a decision how we proceed.
Right, so we can table it so normally we continue to the earliest possible to, we don't want to delay things for you, but obviously that might not make sense in this case. So we would look at probably continuing to a date certain a little further out to avoid renoticing, and/or, the other option is to, withdraw, but then you pay for all fees if you come back,
11
so.
and 25.
So you're saying we could just say 2 weeks, and then if you don't have your letter, then we'll just have to continue it, right? Is that what you're saying?
Yeah,
Instead
so
of putting
normally
it
I'd
out a
say-
month.
Right, I'd rather continue it as soon as possible to the next meeting, so that we can, get some
That's the 28th
opinion.
current, right?
Yeah.
And then if we don't have something in, we'll be in contact and
Postpone.
may have to get postponed to the next meeting.
Understood.
Yeah, basically, I don't want to put you on an agenda and waste your time either, so.
So the next meeting's the 28th,
Yep.
and at 7 o'clock.
Yep.
Mr. Chairman, I move that we continue case 21-010-LLA to July 28th, 2021 at 7 PM.
Second?
Motion is second. All those in favor?
Aye.
I appreciate your time.
Thank you. You want me to crack it?
It's gonna get better or worse.
Might have to make that conference room announcement again.
Okay, we're going to continue on the meeting. Anybody who is not here for this next one, or previous ones, they can step out. There's a lot of people probably waiting to come in. I do want to let everybody know that there is conference room number 2, just down the corner, that has live feed and audio, so you'll be able to see and hear this. And if a public hearing does come up, then, and you have some comments, you can come back in at that point. So this is a continued case. This is case 21003 SIT, an application from Tammy DeFrancesco, a trustee of Kubota Trust, requesting approval of a watercross event to be held 3 times a year starting in 2021. Property is located at 214 Raymond Road, Nottingham. It's identified as map 69, lots 8 and 10. So this is a continuance from a previous meeting, and the continuance was so that the applicant could go to the zoning board, apply for a variance. That variance was granted by the zoning board. So that brings them back to the planning board for site plan approval. We have received some information, quite a bit of information that came in just recently. So we do need to go through a little bit of that, and I'm going to have to rely on the applicant for getting us up to speed on what information has been submitted just recently, and potentially we'll ask the SRPC representative to also provide a little bit of information here. So with that, I just would turn to the applicant. Please identify yourself.
Scott Frankowitz from New Hampshire Land Consultants.
Hi, Tammy DeFrancesco, 214 Raymond Road, Kubota Trust.
Great, thank you. Yeah, if you could just step through.
I can give you a little update, and then I'll turn it over to Tammy to explain what she submitted recently, all the paperwork. So as you know, we submitted this back in February as a site plan, went to the planning board a couple times, and it was determined that we needed a variance for change of use. We went to the zoning board, had a couple meetings there, and ultimately got the variance approved on June 15th, sending us back to here. I received today the planner's review that was dated July 12th. It looks like there's a lot of notes that have to be cleaned up and different things. Nothing substantial that I saw within that, and that's where we stand right now.
Could you just show or indicate some of the updates and plans? Because we received plans back when the original application was submitted. There are some plans that are different that ZBA reviewed. So just make sure that we're looking at the same plans. Jen, do you know if those are in our packages? The updated ones?
They should be.
Okay.
Yeah.
I believe they're I think we got through the plans at the planning board level and changed what we were changing really before we went to the zoning board, which was moving the campers and the parking and stuff. I believe that was on the last plans that was submitted to the planning board back March, April.
The moving of those off of lot 8.
Correct. And that, we haven't done the updates on the plans as we just got the review on Monday.
Well, the plans that we still have the overflow parking and dry camping on lot 8. Is that still correct?
I do have, at least the plan, I think in the packet, we do have one that does show it removed. At least I printed this off the website today, and it did have that.
Plans that were revised on April 8th. However, I will note we only have sheets 2 and 4 electronically. So I just noticed that the set that was passed out has.
I mean, I remember seeing it, but
It was an 11 by 17. And
was it submitted?
that was in the binder today.
And those that we just passed around shows the new, I wouldn't say new, it's been on a few months, the parking configuration. and camping, taking everything off lot 8.
Dirk, you can take mine, because I have full sides of these if you want.
Yeah, if you wouldn't mind. It just didn't make it into my packet.
So those are the two.
Yeah, you have that.
Yeah, I do.
Okay, so this is updated, it says April 8th?
That's the revision date on it, yes.
Okay. And what else is revised on this plan versus the one that was originally planned?
I don't believe there's anything other than reconfiguring the way the parking was shown and the camping was shown.
And how about the comments? Public Works had comments. Did those get updated onto this new plan?
The emergency plan and stuff like that was
Yeah.
kind of, they did not. I don't know that there was anything that was a plan revision. It was more of a come up with an emergency document, they call a plan, I guess. And they talk about having to go out there prior to any of the events and walk through and make sure the emergency plan is in place. So it's more of a document than it is a plan revision.
Okay, and have we received that?
I don't, did that get submitted with?
I submitted these. I don't know if they're all in there. This last map just kind of shows where these are gonna be, only because it's not really anything else besides these couple of events. So these emergency assembly areas are on the south and the north of it.
Okay.
Here's copies.
Can I keep this?
Yep.
Okay. Thank you.
Thank you.
Can we get one of those in the file?
Yeah,
Oh,
I'll-
these
we
the
can have this one.
DOT.
And I think it's the driveway permit and some other correspondence we do have. So there were, going through, and you probably may not have had time to digest all these comments that came in from the RPC. I'm just going to pick out some ones that I just wanted to get some feedback on. And that is, there was a request to provide secondary access, like a secondary emergency access, whether it's pedestrian or just something that a emergency could get in and out of.
Yeah, and Tammy can speak to that.
That was something that we just found out because everything wasn't posted online, but along the whole back of the property, it's Bear Paw and Selt properties, and it goes out to Stingy River Road. You can cross over that without any bridge or anything. You can get out to Stingy River Road from the whole back of the property.
So there's a trail system.
There's a trail system.
And that's traversable by
Walking.
four-wheel drive maybe, or
If you were allowed to drive on, if you were allowed to drive on the conservation area, but through our property,
well,
you
if there
can,
was an emergency.
emergency, yes, you absolutely can drive through there.
A hell of a ride in an ambulance.
Well, we've got a gator.
There we go.
But it
No, we have a trail that meets their trail, and it's really not that bad.
Okay.
and does it exit anywhere?
It exits on Stingy River Road.
Oh, okay, thank you, sorry, I missed that. So a question on the, so on the, in the, I think it's in the driveway permit from the DOT, there's a couple of things, and maybe these are just misinterpretations by them of usages. So they mentioned three residences, but it's actually, 4, because you have the apartment in the commercial space, so it's actually a 4th residence. Normally, a shared driveway can only go to 2 residences and then becomes a road.
Yeah, that's why the town's been talking about changing with E911. They've been talking about it for a while.
Yeah.
Of renaming it, so I don't know really how that stands.
So we've had that come up before, anytime there's more than 3, and this, again, has 4 different things being served by what's currently a shared driveway, but in the DOT permit, I think it's in that, it mentions also that, winter racing.
I don't know why they put that in there. I
They're
have
not
no
to
idea why they put that in
snowmobile
there.
and-
Yeah, no, I don't know why, they added that in themselves.
Okay. So that hasn't changed, there's no winter racing planned
No.
or anything?
Just, not against anybody, but let's just keep the conversation directly between the applicant and the board. Okay. Make sure that that stays consistent. There was some communication with the building inspector, not communication, but comments. I don't know that those have been addressed, so there's some attendance questions. There's egress, I think we already covered that a little bit. Some of the dry camping items here, it says about having potable and flushing toilets.
Yeah, I spoke to him about that. He didn't understand what dry camping meant. All we meant was it was self-contained, that when they come in, just like they go to Lee Speedway or they go to NASCAR, they just come in with their own water in their tank, so they can flush the toilet, and they dispose of it either with Emmy's porta potty service, because they come in and do all of ours, all the porta potties, as much as we need it pumped. They come in and do that, and they'll pump the campers, or the campers can go to Pine Acres and have it pumped afterwards. But it was just for the sole purpose of saying that everything's contained. They do not let any waste out anywhere. They hold it all in their camper. So if they don't have a camper, that they're not allowed to do tenting or anything like that. Everything's self-contained in their camper.
And then I see, okay, so you get 20 camping spots. And the plan that the April plan, the most up-to-date one, has car parking overflow onto Lot 8. Is that
That's
what's
we're
proposed?
Proposing, right?
Not everybody stays at the same time, so some of the spaces that show as parking spaces, they're only there for a few hours and they leave. Somebody else comes in, so it's not always, they're not always full.
Do you know how many cars are shown just on the depiction there?
Don't.
No, I'm just curious.
The picture that we had, you have an aerial view of an actual event, and I counted probably 150 cars I could just see in the aerial view, and there was still a ton of room.
And that's similar to what would be planned under the site plan?
Yeah. I mean, we live there, and as everybody else is concerned about any other issues, we don't want overflow, we don't want bad things to happen either, so if it's not gonna fit, it's gonna not be allowed.
We're showing about 68 spaces.
A lot of people come in and carpool together.
If I remember correctly, that was all grass. It was no pavement, no change in that planned. It was all, marked, painted out on grass.
Mm-hmm. We have volunteers and staff that help people park. Some of the parking staff is here today, but they angle them in and they park them, so they don't park themselves.
And there seem to be some conflicts with operational times or event times between the DOT permit and maybe something that was on the plan and some other things.
There was a mistake. The only times that they practice is on Friday from 4 to 6. We have cameras 24 hours a day. 4 to 6 is practice on Friday. On Saturday and Sunday, it's from 10 to 6. They might hear engines start a half an hour before and a half an hour after, just to get them back to their trailers.
That was a note on the plan that we'll revise to 4 to 6 for Fridays. We had 2 to 4.
Yeah, can you add either a note or a location where maybe the other egress would be, the emergency egress, show that on the plan?
Should we also touch upon under, I guess it'd be section 2 of the comments, it's on page 4 of 6 at the top, the part D, the setbacks.
Right.
Is that something you guys have looked into, just as a response?
We can show them, but they're really, I think they're irrelevant. They're not really based on, we're not building anything. We're not constructing anything. I don't think the regulations prevent parking within the setbacks, but we can definitely show them.
Okay.
Well, the proposed pit area too doesn't have any kind of setback from the abutting property is proposed, is shown on the current plan.
That's not a construct, and there's nothing being constructed, so your setback would be for structure setback, not for use or for parking.
One of the things I noticed when we did the site walk, which was helpful, I know noise has been brought up a number of times from the butters and such. And I think some of that possibly could be mitigated, but I don't know necessarily how, so I'll mention it to you and see if you can kind of think about it or get back to us. So so most of the property are on the eastern side, you have a berm, that's showing. But where everybody accesses the property is the lowest spot. So that's where in a way, it's non-engineered, but all the noise would channel out that way.
Well, we said,
or the majority of the way. So I don't know if there's a way to add a
we had
additional
suggested,
buffer
we had
around.
suggested for now to put Jimmy's construction trailers that just have his tools in it, to be able to put them on each side of the driveway to act as some kind of buffer for this year, and we'll work on doing something for next year. A fence.
Because I think that was the only place that really had a break, in the, and I understand why there's a break there, but again, that's where all the closest of butters are.
We just want to, if that's what you guys are proposing, then we'll need to have that added to the plan.
And one thing that was mentioned during the site walk was that the plan for this is 3 to 5 years, that this isn't planned long-term, that, that you're gonna return this to grade, most likely in 3 to 5 years.
The gravel pit?
Right.
Well,
the
there's only
gravel
so,
pit,
there's only so much that we're able to dig from the
Including
pond with
the
our.
pond.
Yeah, there's only the pond is our gravel pit area that we're able to dig from.
Yeah,
So there's only so much that we can dig to,
yeah.
so.
But I know in site walk, Mr. George, I apologize for the name, but he had indicated that, that the life is running out of it, and when it's done, it's gonna have to go back to grade, and it's, including the pond, was gonna be going back to grade.
Well, just like the whole, if you look at the pit permit,
Yeah,
everything that's grass, all was big piles.
yeah,
And after we have to reclaim it back to natural state
right.
with a 3-to-1 slope. So everything, after we're done digging, it's all gonna be grass around it. Like
But it
all,
wasn't stated around it, it was stated that it was gonna be filled in. And
no, not filled in.
that's what was stated at the site walk, that's why I'm clarifying.
Oh, I don't think you meant to say
It was
that.
stated that the entire site was gonna be returned to grade. Someone asked
No,
the
no,
question.
I think, I'm sorry, that was a misrepresentation.
And the current AOT permit for it is just renewed for 5 years.
Yeah, and I think the other problem is apparently we don't have on file, and it's in our zoning currently, is the reclamation plan. I'm sure it's on file, but the state probably has a part of your alteration of terrain, but
Yeah.
the town apparently, in the 1989 record that mentions it, does not actually have a copy of the plan.
Do you want the one from this year? This is, so 2015 was the last time, 2020.
Okay.
This is-
Yeah, it's possible, it'd be great. Thanks. Thank you.
Can we get that electronically to Jen, just so we can all take it? Do you have that? That'd be great.
Yep.
So the current reclamation plan, even though the pond did not exist before the gravel pit, the current reclamation plan is to keep the pond as it is and reclaim the area
Around
only
it.
around the pond. Okay, so the whole site's not getting returned
No.
back to its natural state. Okay.
Are AOT permits renewable at the end of 5 years? So it doesn't extinguish the possibility that the event would continue beyond 5 years from now?
They acknowledge the event on this year's permit. They acknowledge that they know the watercross and the camping, and they have the plans that has that on there. So yes, the state knows.
And I don't think she was speaking that the event had a 3 to 5 year horizon, that's the AOT.
The AOT, yeah.
Yep, they have a 5-year research.
So there's another comment regarding water quality of the pond and concern of aquifer. Can you guys address that?
What do you guys, I saw on, where's my paper, hold on. I don't know what you guys, what they try to look for as far as that. I was looking at the verbiage that she had in here of the aquifer, consistent with the town's aquifer protection overlay, is that there shall be no disposal of waste, solid waste, or on-site disposal, storage, processing, or recycling of toxic hazardous materials or waste, no burial of petroleum products or unclosed, uncovered storage, rolled salt, or just de-icing chemicals, and there's not any of those in that area. So that's the town's aquifer protection. There's none of that on there.
Yeah, I think for the specifics, I think we'd be looking for a little bit more information on, and I know it's been discussed in meetings about operation of either recoveries of snowmobiles or
So we have,
contained tanks.
we have two recovery boats that go out and take them out immediately. As soon as they sink, they have buoys that have floats on them. I think one of the boat drivers is here. And they go out and they take them out right away. They bring them to shore. The 10-gallon gas tanks that are normally on a snowmobile are replaced with a 1-gallon or 2-gallon self-contained. The only liquids that are in any part of the snowmobile are in that tank there. There's no other fluids in the snowmobiles at all. So there's nothing that can get out of there to do anything in the water. And if there was, we do have, God forbid something happened, we have mats that absorb any kind of oils or anything that could get out in that 1 gallon or 2 gallons.
Sorry, but is that on this prevention plan at all, or is there any? Okay, so that's in here?
In the spill plan.
Okay, great. I just didn't read through it enough to know it, but I know we've talked about it a lot and heard about it a lot. I just want to make sure we get it,
Yeah, Fish and Game-
documented like that.
Fish and Game, they come after a race. They've come the last 2 proposed races that we're supposed to have, because they come after it to look at the water quality and look at everything. And they came and they said, where's the race? And we said, we haven't got approved yet. So, but they still come.
Yeah, if you like, yeah.
On the topic of that, we probably should have, being a commercial site plan technically, somewhere in the notes, whether it's the existing conditions, we should probably make reference that it's located within I don't see it on, it might be on here, but just make sure somewhere in the notes on the plan that it's referenced that it's in the aquifer overlay district.
On the zoning board, we had brought to attention that Epping's aquifer zone is
Yeah,
all in
overlaps.
industrial, and I'm like, we're not trying to build anything industrial on it, and
Sure. No, it's just one of those, it just needs to be called out in the zoning,
Okay.
just so that it's stated. Thank you.
In mentioning the Aquifer Protection District, so in the Aquifer Protection District, we have permitted uses. We do mention some non-permitted uses, but anything outside that, it's assumed that we're a permissive ordinance, so if we state what's permitted, everything else is considered non-permitted. So I think because that's in zoning, it would likely require
so zoning.
further variance. Because it's a commercial use.
So zoning, did they make that condition, or do you guys add it on the zoning requirement?
In our zoning ordinance, we have the Aquifer Protection District, and in there, it lists just the permitted and non-permitted uses. So if it's not listed as a permitted use, it's considered non-permitted. So that would be a further likely ordinance, variance that would be needed.
So are you saying we have to go back to the zoning board now? Is that what you're saying? That's what I'm gathering from what you just said.
That would be, that's my interpretation of our zoning ordinance. Again, we have so our zoning ordinance is permissive, meaning we either state what's permitted and everything else is therefore non-permitted.
But I'm confused how they already approved it.
They
with
can
not-
only approve the items that are specifically requested relief from.
I guess what we applied to the zoning board on the guidance of the planning board, variances were required for the site plan. That's what we did. Now, we're throwing a bit of a curveball here.
I don't know.
Because the variance was for a change of use.
Right,
So
from,
doesn't that cover,
does not, the variance only covers specifically the item specifically requested variance from, relief from.
change of use for a water crossing event?
So Article 2, or, you know, whatever article specifically was requested for relief from, which is granted.
I mean, if they need us to do a water test after every event, if they want to see, but it's been a proven fact that every water cross that goes across the whole United States, the water quality is actually better, because it's agitated, it's moved around, it's not contaminated at all, so.
So Ed, the variance,
So if they give us conditions of what you can do on an aquifer, do they also give us a tax break on the property? For the aquifer issue of the whole pond? Am I gonna get a tax break on the
No, we're
7
not-
acres?
We're not here to talk about tax breaks. That's not
So
our
just-
purview.
the variance reads, Article 2, Section C of the zoning ordinance, to permit water cross events with incidental camping, i.e. commercial use, 3 weekends per year, and then on lots 8 and 10. So is that would be the approval of the use, right? 'Cause
That's
they're-
the
they're-
approval in the residential zone for a commercial use, but there was no request for relief from this more strict standards of the Aquifer Protection District.
Yeah, just reading just straight from the Aquifer Protection District. The first permitted use is any use permitted in the underlying zoning district.
But because they got a variance,
They've got a variance to the underlying district.
So what does that
It's a
mean?
little bit circular.
basically saying the Aquifer Protection District prohibited use sends you to, if it's a permitted use in the zone, they then went to the zone, it's non-permitted use in the residential zone, so they obtained a variance for the use in the residential zone that then comes back to the aquifer, the article for the aquifer protection, so it's somewhat circuitous.
Yeah, circular. Yeah.
My opinion would be that they have a variance for a use in this zone. And the district is an overlay too, it's an overlay over the residential. So that's why the underlying district is always
Yeah,
referenced.
I think that's a little bit undue burden on the applicant at this point, where we've already sent them to the.
Yeah, I think because of what Jen read, I think that kind of confirms that it's,
Yeah, I think.
otherwise you get stuck in a circle going back and forth.
I think we're covered by that.
I would think so.
I don't know, I'd want legal review. I don't like to step on the toes of another land use board or take away their authority. So I don't think we need to.
Well, the other point is that they didn't bring it up at that point. And I know it's not, if they can only review what they have in front of them
That's correct.
as asked.
They
I
can't,
understand that.
and they can't go outside that, or there's, as they've advised me before, they do not go outside that authority. They only speak towards the specific variance that was requested.
So are you,
We feel that it's covered by the underlying district.
Ed, is your point that because the variance didn't specifically mention that the property is located within the overlay, is that what's getting you caught up?
No, that we have a specific aquifer protection district that has more stringent standards. And it lists out specific permitted uses and all others are not permitted.
Well, I think that it's come down to an opinion.
I just think because of the aquifer protection under subsection D under permitted uses is any use permitted in the underlying district. In theory, it was a non-conform or unpermitted use, but now this variance specific to this property makes it a allowed use on this piece of property.
I don't think it hurts to get, a legal opinion from our town council just to make sure that we're in line. Again, I don't like to take away anything from another board or the applicant or the public, letters and such.
Well, I mean, there might be enough enough items in this list that, I mean, we don't have updated plans, and there's a lot of information here. You haven't really even gone through all of the comments.
I read through the comments, and 95% of them are note edits.
Okay.
There was two of them one that we already covered was the setbacks. We can show the setbacks. Then the stormwater one, which we're not proposing any improvements on the private property, no pervious, so I don't think there's a need for stormwater analysis on this. There was discussion about the access easement. I read through the easements that are on record that were submitted. There's no limit or mention of what can be, and it's just an access easement for
And you're talking about the access easement that allows access to the abutting property?
To the back property, and also the easement.
And what was your conclusion of that?
The easement actually reads, included in this variance is a perpetual right to use for all customary purposes the right of way from 156 to the described property. So that kind of is a global, all customary use. I believe at that time, back in 1984, it was already a gravel pit, so.
I mean, does the plan allow for that access
Yes.
to continue?
Yeah, well, there's a 50-foot access easement from 156 down through that property to the existing gravel pit, and then there's another easement from there back to the James property in the back that's just shown on the plan.
All right.
And noted plan references and everything that go along with it.
None of the event operation will block that.
No, as stated before, the gravel pit will be closed during any of the events, so there'll be no traffic conflicts.
Well, no, I'm talking about access to the abutting property.
Right, no, there's the road that will be left open, no parking is proposed within the gravel access that goes out to the back property. And the butter is present, will speak when it becomes time for the public to speak.
And I apologize for coming back to this, but the verbiage that was hanging me up, I knew it was there, I just couldn't find it, so so Article 3A, so Article 3A, and then number 3, lowercase a. The Aquifer Protection District is a zoning overlay district which imposes additional requirements and restrictions to those of the underlying district. In all cases, the most restrictive requirements shall apply. That's why I felt like it probably would have to have specific relief from this district by zoning.
Well, I guess I would, if anything, defer to getting a legal opinion on it, but I think it's unnecessary for this applicant to do that. To go back to the zoning board when they were just there.
And that's always the purview of the applicant. If they go before there's a final decision by the board, and it's a savings clause for the applicant as well, that when they do that, they can go back. But
Yeah, it's not just because the planning board said one thing that you only have to do one thing. It is the responsibility of the applicant to make sure that they're going to meet all of the right zoning, because we don't have the whole picture, we don't know what else you're doing, but in this case, I don't think, I do think that we're probably covered by that, but I do want to make sure, as Vice Chair has brought up, is, make sure that we have that covered.
And they do know, I mean, it's such a minor use that it's only 6.5 days a year out of 365 days.
and that's why I was saying the alternative is, we get just legal counsel, opinion that way before we say, go back to zoning and expend the funds there of the butter notification and such. It's, wait to see what town council says. If they say, no, you're all set with where you're at, then, then I think generally that appeases, my feelings, wages that I'm not stepping on the zoning board's, jurisdiction.
Well, look, I do think that we do need to have, like, revised information to us. I don't think we're close enough to provide a conditional approval, because there's just a lot of information here that still needs to be updated on the plan.
just wanted to clarify too, that the documents that had comments, there was a technical review document from Dale, the building inspector. Fire department had its own review. Technically, there was some, questions on behalf of the Conservation Commission. Does that need to be addressed because it is a commercial site plan?
Yeah, and that, again, that's just something that came in today.
Just be responded to, I guess, essentially,
Yeah,
because it was
right.
another board of the town, and then there's the SRPC comments. So those,
Right, it's not just these comments, but there's
Yeah.
other information that just came in that we want to make sure is all responded to by the applicant.
Yeah, and I don't believe that Conservation Commission letter that just came in, there's nothing to really respond to. It was,
We just had our meeting on Monday, and then,
I'm just saying the letter that we got. I'm just saying it's suggestions and stuff, but there's nothing for us to respond.
yeah, but certainly to keep in mind
Yep.
as we move forward.
We're happy to accommodate over the time, so.
But again, I mean, the planning board just got this as well, so
Yep.
we haven't had time to fully digest it, so that, I mean, the Conservation Commission makes recommendations or requests to the planning board, and we're just getting this today, so we have to digest it to see if this really, if there's some elements of this that we want either shown or answered, responded to specifically.
are you looking at the, I don't know what the date is on this, the one with the attachment on it, is that? Yeah, she just has those 3 recommendations, which technically the Conservation Commission or the Planning Board, they provide the recommendation. It seems like 2 of the water quality and vehicle traffic you guys have already talked about a little bit, but it might just be worthwhile while you're responding to the other 3 comment documents.
Right, if you can show what, maybe that noise mitigation of the trailers, that probably would respond to this
Okay.
as well.
Comment about something. On the permitted uses, it says right in here, now we're talking about farming, and I'm just gonna say, since we're talking about water quality and stuff here, we put in here that it's okay to use fertilizers, pesticide, manure, and other leachables are used in accordance with the best management practices as described as Rockingham County. So in our zoning ordinances, we talk, I mean, right here, as people are discussing about water quality, leaching, and toilets and stuff,
That's an allowable use in the.
allowable use, I mean, we're talking, I mean, so I don't see where the concern is.
What page are you on? I'm just curious.
On, section number 8, page 3, where we talk about, permitted uses being farming, but we're talking about manure, fertilizers,
There's
harm
a,
chemicals.
there's a big reason for that specifically being in there. It's because we're an agricultural town, and there's agricultural restrictions, basically, if you go back to the state and the RSA's and
Well, I
things like
understand that, I understand that, but we're here to interpret this also.
But are you trying to interpret that?
Well, there's
that
nothing
this
says,
is a farming
we're not gonna
garden?
write an ordinance says that they're allowed to have a water cross and put that as a specific item. I mean, that'd be kind
Could
of,
say commercial racing, something like that, but it's not currently a permitted use. You can't, so of the 3 that are listed, 1, 2, and 3.
you could have 1,
Does
2,
this
3,
fall
4,
into?
5, 6, 7, you could make a
Right.
whole bunch of different ones if we wanted to keep adding to it.
But we didn't. So the way the current zoning ordinance is written, we've specifically listed 3 permitted items, all the rest is non-permitted.
John, if I could just jump in the
I just think
case,
it's just something that.
in the case of an aquifer zone, there are restrictions on the numbers of animals that you can have.
Oh, yeah, it says
on your
5.
farm.
Sure.
Yeah. So it's not,
But it doesn't say if it's 5 bunnies or 5 cows, which are gonna be a whole different amount of,
true, but there
What
are
we're talking about.
restrictions that are addressed.
again, not being specific, is what my thing is. Where we're trying to be specific, when there isn't specifics in there. Just my opinion, just throwing it out there.
What are the 3 allowed?
Any use permitted in the underlying district of the zoning ordinance except as prohibited in section 3C or regulated by a special exception in Article 3D of the article. Maintenance, repair of any existing structure, provided there is no increase in impervious surface above the limit established. Section 4B and section 5F of this article. Farming, gardening, nursery, forestry, harvesting, and grazing of no more than 5 animals. Turf management, provided that fertilizers, pesticides, manure, and other leachables are used according to best management practices as prescribed by Rockingham County Conservation District, if applicable, and at levels that will not cause groundwater contamination. All said leachables must be stored under shelter. That's it.
I guess I'd ask the similar question as with the spill prevention plan, emergency plan, do we, as a board, feel like it is in tune with protection of that aquifer based on our zone? There seems to be a lot of
I'm taking
practices.
feelings out of it, because it's not, our document's not a feeling document, it's,
Well, yeah, but we're
Written.
here there's only so many details that can be put into it. We do have to go between the lines and try and understand what. you know,
If it
what
was
these-
black and
what
white,
these-
we wouldn't be here.
Right, what these documents are for, that's our jobs, is to interpret them.
and write them, which we've done and the town's voted on, and this is what the town has said is our zoning.
Yeah, but that only gives us guidelines.
But, yeah, I mean, I think the way forward is, we have town council, just throw it to them and say, is this in our purview as what's been granted so far?
I just think that subsection 1 there, just any use permitted in the underlying district, still goes back to that circuitous. They have a variance for the use in the underlying district. I think that's
Except
one of,
where back above it, anything more, it specifically states that if there's more stringent regulations in this, that this applies. So again.
right, but they're,
Once you approve, if an application is approved,
but if you look at
there's
the
no going
prohibited
back.
use.
So site plans might have to get reapplied for, but the zoning doesn't. So the zoning only applies once. So no matter if it's this application or a different application, once we approve it, it's permitted at that point.
Right.
Versus, and it doesn't matter if the scope is gonna, could potentially change in the future, not that the applicant has made any indication that they plan on that. But, they would have to possibly come back for a new site plan for an expansion. But the zoning wouldn't apply at that point, because it would already have been.
Right,
Granted.
but even if you go further and do that second half, except as prohibited in section 3C, that brings you back to prohibited uses. The watercross event doesn't propose specifically any of the 9 prohibited uses. There's petroleum involved in the sport, but it's not a buried storage or petroleum fuel or vine product. It's just that clearly states 9 prohibited uses that technically.
I'm sorry, what page is that? 'Cause what's the 9?
This is, page 10 is the start of the overlay, and Article A is the aquifer protection. Section 4, subsection C at the bottom of page 10 is prohibited uses. So then there's those 9 prohibited uses that go on to page 11, and then the next section, subsection D, is the permitted uses, and subsection 1 is that sentence that I've been reading about. They essentially, they got the variance for the underlying district, and then there's the second excerpt about unless it is specifically prohibited in the section before it.
Well, I'm not in favor of punting all our responsibility onto somebody else's.
Yeah,
I guess I'd just ask the rest of the board if you feel we should turn this over to legal, I'm more than willing to do that. I'd like to get a consensus.
And I don't feel that's punting. I feel like that's doing due diligence for the applicant and the town.
Well, we do have a responsibility.
And we have legal counsel for a reason. I mean, we're talking about potentially continuing this anyway. So I don't see what the harm is in making sure that we get it right.
So even though that there's going to be a legal, I said what I was going to say.
do we need to have a,
I
Need to
agree
be
that.
voted on, or?
I agree that we don't have enough information to get through even a conditional approval. It's just, the list is too long right now. That, we've got too many things that need to get updated in the plan and information that needs to get provided to the board. That's only my opinion. I'm obviously going to bring it back to the board and whether they feel that way. But I would like to hear from it's a public hearing, so we've also continued the public hearing.
can I throw in one more comment before we go on? This is just the last comment I had, and this is in reference to the AOT, letter from Beth Ann McCarthy from AOT. There was reference to the need for an after-the-fact wetlands permit due by July 31st. Is that?
That has nothing to do
Is
with
that
this.
off property? Okay, just want to
No.
make sure. All right, that's it, thank you.
Mr. Chairman, I'd like to make two suggestions to the applicant that we haven't discussed yet in detail, if I may do that.
Sure.
Okay. We have mentioned noise abatement for abutters. Are there any plans to address that for people that live close by?
We're gonna try, that's what we're talking about, putting the trailers up for this year.
Uh-huh,
And then
but no barriers?
doing a fence, well, we're talking about, we want to do a fence next year. Not only, we want to do a fence next year, but with all these other expenses going out and everything that we've been put through for the past year, we just don't have the ability to do that right now, all the time.
But certainly trees would help as
Yeah,
well.
we definitely plan on doing that. We have like, just so you know, I don't know if you've got to see between all the departments we've been through and all the letters that came in, we probably have 9 direct abutters, including Artie and us, having 2 properties each, and 5 of them have written letters numerous times that they're in favor of it. 5 direct abutters. So I know other people have signed in here as abutters and they're not abutters. They've lived a mile away, but the 5 direct abutters that we have are 100% in favor of it, especially Artie Jenks, which is right behind our property, that everybody has to drive through his property, our property, to get to his. So,
Okay, my second issue is that when people come in and leave to enjoy the events, they have to come in through the driveway, which crosses the Pawtucket River, which is the state protected river. It's a first order stream, and they're highly monitored by DES. Will there be any structures or conditions changed so to prevent sedimentation maybe coming?
I
from-
honestly don't think that the cars coming in, the cars that do come in are a lot less than the dump trucks that have been coming over for 40 years,
Okay,
honestly. And the habitat is still there. Like I said, we live there. We're not going to do anything to endanger anything.
I was just concerned with the numbers rather than, just.
Yeah, no, like I said, they carpool. Most of them come in together. Some of them walk.
And some of the questions, like right now you live there, but unfortunately, like once something gets approved and the variances are granted, it goes with the property, so.
But it still has to go through the special permit of the select board.
Yeah,
So they have to still put conditions on it. They can still, even though we got granted for it, they can still make conditions that we can't do it.
I'm just saying, so sometimes when there's question, like right now you're living in a home, but that could change and so
You think somebody else would want to go through this?
conditions could change. So I'm just saying, once something's approved, it's
I understand.
it's approved. That's why sometimes, in the abutters, I had that same thing before, trying to make sure, is it direct abutters, but people are still abutters even if they're not necessarily contiguous abutters.
I
I had that question before on another.
No, I do understand, but like I said, from the zoning to you to back to the select board, it all comes back to the select board having to give us a special application. So if they don't give us the application, we're not doing it. So everything that we're going up and about and around and around and around, it's still up to them. How many spectators are going to be there? Okay, let them monitor it. Just like last year, if there's too many, if it becomes a problem, they put a limit on it. There's so many things they can do because they're in control of the permit. So at the end of the day, it takes, I know what you guys are looking at, and I appreciate everything that everybody has done, but at the end of the day, it still comes back to, they still have to give us the okay at every single event that happens.
Any other comments to the,
Yes, I had just a quick one regarding the safety plan. I noticed in the plan, it mentioned hiring of EMT and police, I believe. And it did mention fire extinguishers for the riders, I think.
They have to, it's part of their rules, they have to have one in the trailer with them at all times.
Okay,
And we're gonna,
and I hadn't seen, anything from, say, our fire department, but I was just curious as whether maybe the chief had any thoughts
didn't-
about fire other than.
he didn't say anything, no, he didn't say anything about that, but we did get another letter from the firefighter, a chief in Raymond, that said that he witnessed it, there's no traffic, there's no issues. Other people that have written letters that have attended people in Nottingham residents have attended the event, they're firefighters in other places and said that everything was well-maintained, and so, I know it's hard.
Yeah, that's just not official.
I know.
So,
Yeah.
we can only go by our,
Nope, the fire department,
our own-
the police department, and the EMTs are there at every event.
yeah, and to answer, Gary, we do have a comment letter back from
Okay, I didn't
from
see
the
it.
fire department that had specific things, emergency access and whatnot. So they have reviewed it and provided comments. I don't know if they were at the site walkthrough, but they were very familiar with it, as well as the police department. They had specific requests of having, places where two duty officers or something like that. I don't remember what exactly it was, but, so those they have to be complied with.
Thank you.
All right, so let me open it up to the public, and since this is a continued hearing, and I just want to mention to, limit the amount of, I don't want to limit anybody, but limit amount of repeat, is that we've already had public hearings for this. We've heard a number of people for and against. But I do want to make sure that if anybody has something new to say, you're more than welcome to say that. But if one person has said it, just don't repeat it. We don't need to have 5 people saying the same thing. So all the information is for the board to be able to make our decision. It's not mass and numbers. It's just really what the board can use to help us make a decision.
Thank you.
And then if you could, when, anybody who wants to, I'll ask anybody who is in favor to come up to the microphones. Please state your name and address, identify yourself, and I'd rather not have very long comments, and if it does become very long, then we'll put a time limit on it, so.
Do we need to institute that beforehand at all, or?
What's that?
Can you institute that?
I can.
Any time, or-
Yeah, it won't take any more comments longer than 3 minutes. So you'll have 3 minutes to make comment. Yes, sir.
Mr. Chair, can I speak? This is not for, nor
I'm
against
only,
it. It's
I'm only
my
taking,
name is,
nope, sorry, I'm only taking people that's for the application. So anybody who's for the application will speak first.
Sure.
And then we'll go to anybody who is against the application. And then we'll go again to anybody who is neither for or against. So anybody who's for,
Robert Claxton, 85 Ledge Farm Road, Nottingham, New Hampshire. I didn't know what to expect this, but we seem to get hung up on the water quality thing and worrying about the aquifer and the gas and whatever. Duckaway Lake's what, quarter mile away from this location, straight through the woods. How many hundreds of boats are on that? So as far as the gas concerned, on a little pond in a sand pit, I don't know if that's maybe the legality of the aquifer regulations and all that make it sticky. But listen to that much about that when, I don't know if Pawtucket is considered an aquifer, but I mean, there's thousands of boats been using that for however many years, 100 years of activity out there with gas engines for the past 70. So I think they get hung up on that too much. It's kind of moot point at this, for the size of the pond and the quantity of gas. I know what they have. It's less than a gallon. So and they're not spilling it. Every guy isn't dumping gas into the lake or the pond. If they're riding around, they're not spilling anything into the lake, or the pond. So it's not that perception of what it is, It's not raw fuel dumped in. That's it. Thanks.
great, thank you. Yep.
Lee Weldy, 110 Nottingham Road, Raymond. I live 800 feet from the corner of the pond to my house. You mentioned the aquifer protection zone, go up and down 125 in Epping, and that whole zone that's all commercially developed is an aquifer protection. How far is your septic tank from your well? Anyone know the zoning ordinance? How far your well's from your septic tank?
35 feet.
75 feet, thank you. Okay, so you're worried about that. You're worried about the water quality. How many of the culverts run the 156 and feed into that river? It's not a limited salt restriction area. State plows go down, they're dropping salt near that, I forget what the number is, but the log cabin, there's a culvert that runs under 156, and then there's one up near my house. They're not concerned about sulfates or anything else. They're dropping all the salt in the road. There's no ponds, there's no protection for runoff. It goes right into the water, which runs right behind their property and goes right out through the river. So as far as what's driving over the bridge, you got a car going over back and forth, a truck or whatever it is. They're not dumping something on the bridge, which is what's covering over the road. So that should be a negligible issue. All these cars going up and down 156, I'm not really concerned about them, because those culverts feed directly right into the river. They're over 75 feet with a berm, and you mentioned the gentleman before you mentioned the liquids. Do you understand what hazmat spray is and how much is required to spray before you have a hazmat situation? Anyone here?
Off the top of my head.
5 gallons. You have 5 sleds with less than a gallon each on that pond. If you had a catastrophic failure and all 5 of them sleds crash, you'd have less than 5 gallons. You would not have a hazmat spill. Their spill mitigation plan would cover it. So you get 5 sleds, 5 gallon, or less than 5 gallons, because they're only a gallon in a sealed container. You'd have to have all of them have a catastrophic failure before you'd even have to notify them of a spill. So you're not going to have a problem. Fuel and oil float. They have the booms, they have the mats to recover the fuel. Fire department or the ambulance squad is there if there's an issue. So you don't have a problem. The fuel and oil float to the top. It's not going to go into the aquifer protection. They're going to recover it. That's what they do when they have these tankers that crash out in the ocean or have issues. They put the booms around them to keep them in the area, and they recover the fuel off the top of the water. It's not going to go into your soil. It doesn't sink to the bottom of the soil. So it's not going to go into the river. It's not going to go into your water. It's not going to go anywhere else. I know Tammy. Her well is a dug well. Draws off the water, the ground, or basically the water table. It's not something that she's going to want to pollute. It's her own well. It's not an artesian well. It's not below the ledge. So all this ground level water contamination, if any, should happen. As a sled sinks, the fuel tank is completely sealed.
Can you just, we've got about 30 seconds left.
I'm done. I think that your concern should be not about the aquifer protection, because it is, you don't have enough fuel on the water to even be concerned about.
Thank you.
I'm going to open the door.
Hi,
Hi.
Tina Jennings, Siemens Point Road, Nottingham. I don't really know much about aquifers or about fuel or how it all spreads or any of that. I don't even know Tammy. But what I do know is this event and the fun that it brings to my family. And especially last year with everything being shut down and being a pretty gruesome year, it was kind of nice to have something fun and outdoors to do. When I was in a different location ages ago, my dad used to take me when I was a kid. And I have good memories of it. It's a family fun event. It was very respectfully run last year. I know my kids were begging for whoever's in charge of it to let the people jump because they wanted to see the jumps happen. And whoever had the microphone was like, we can't because it has to end at 6 because we need to be respectful of our neighbors. And the kids, they wanted to see the jumps happen. And, they're trying to be respectful, trying to have a fun community, family event for everybody. And I know I appreciate it. So, thank you.
Thanks.
Hi everyone, my name's Caitlin Brown, 214 Raymond Road, Nottingham. I just sort of wanted to follow up with what the last person just said. I know that it's the board's responsibility to look at everything in great detail, but I would just also ask the board to look at everything that the applicant in this case has done over the past year or so in order to try and do everything right in this case. There's been so many meetings, so many different plannings, attorneys, efforts made to contact abutters, to do whatever can be done to minimize any of the negative impacts and negative effects that this event could have on the community, and has just tried to focus on the goal of making this the best event that they can and minimizing any negative sort of things that could come along with it. And so there's just been a lot of hard work put into this. I just think that it's important for the board to know that the persistence is because there's a lot of passion behind this. They want to bring something good to the community. It really is a good thing. I think that the most negative thing that we've heard over the past year or so is the noise that impacts neighbors. But I think that on the grand scheme of things, looking at everything from a 50-foot view, the greater good, the greater thing that can happen here is an awesome event that would be really beneficial for the community, and for residents and kids, and it's a lot of fun. And I just think that I hope that when the board is reviewing the site plan, that they will also consider the bigger picture while they're looking at the finer details to do your job.
Thank you. Anybody else for?
I'm going to keep this short. Robert Wygant, 24 Guile Road. Pardon me if you can't hear me too well. I have a broken jaw.
No, I can hear you. Sorry to hear that.
Thank you. I want to speak a little bit about punting this back to the zoning board. Setting up an event like this requires, advance notice, and they're trying to fast track as much as possible. With having already gone to the zoning board and the zoning board approving the variance, the circuitous situation that you had pointed out, it almost appears as though they sort of, the zoning board had approved for whatever that new zone is in. So which would then bring it to the planning board, in your case, to punt it back. It appears as though it's just going to keep running in a circle until every single I and T is dotted and written into law, or written into ordinance, which will never happen. It's constantly going to change. It's constantly going to be in motion. But I think keeping it in the hands of the planning board will allow this to actually happen. If it is something that we as a town want to have happen. I understand that there's abutters that may or may not want this to happen, and there's issues with noise. Well, I listen to gunshots all day, and that's just a part of the town. I listen to the Lee Speedway every Friday night. That's just a part of the town. This is a part of our character, and an event like this fits right in with the character of the town. I don't think we should be trying to push back on it, but rather embracing it. The same way we as a town embraced Article 19. And we see that we were taking care of these people for years, so now this is what we want to do as a town. And this is looking at us as a community, not as individual residents. Is this event good for the town and the residents? Now, obviously, it's not going to be up to a vote for all residents, but you as officers of the town sort of act as constituents, or sort of act as leaders of the constituents, being the residents. So, I hope you can kind of look at this in terms of its value to the town, in order to allow it to happen. Now, I'm acting as a sponsor with my company, but I could only imagine how difficult it is for them to get sponsors with the uncertainty of what's going on. And with the shortened timeline between now and then, if this has to go 2 weeks, 4 weeks, 6 weeks, the sponsorship ability decreases, making it, and to be honest, when there's less money to go around, the event is more difficult to put on, and probably, there's more issues that can occur. So the faster we can bring this to a decision. I understand they still have work to do to get their I's dotted and T's crossed, but the faster you can get it going, the more sponsors that they can get, the more money they can get to do the job right, which is exactly what they want to do. So I hope you as a board make the decision to keep this within your board, rather than punting it back to the zoning board, which could put them back another 4 weeks and make it very, very difficult to finance this event as a whole. Thank you.
Thank you. Anybody else for?
My name's Giovanni Santoro. I live at 31 Harriman Hill Road in Raymond. So I'm not a close abutter, but I have attended this event. I also frequent the South property off of Stanley River Road, which abuts the pit. And I'll tell you that it's an active gravel pit. There's equipment running all the time. I think the idea that some sleds racing for 6 hours out on the pond is creating more of a sound nuisance than 80,000-pound trucks pulling out of there all day long and, crane cable-operated dredger with a old Detroit screwing along as they dig the pond, which is like great and dandy, but the idea that a sled is making more noise than that is somewhat unfounded. I've been up on the hill in my deer stand, and you can hear the backup alarms, sure, and they get quiet, and it's really not, the sleds really aren't that much louder. The traffic impact is minimal. When I attended the event, I pulled around and off the road. Everybody was funneled straight to the parking area. You're not creating a hazard for the community, and you're also bringing a boost of business to the community. You have sponsors, you have people who are maybe staying here for the weekend, you have people frequenting our restaurants because who wants to cook when they've been racing all day, right? And so, you're by finding a new way to shut this down at every turn, which, and I'm not implying that anybody is. There certainly are some folks that are, but they're really doing an injustice to the property owner. They're just creating absolutely monumental hurdles to have to keep jumping over for an event that's already been held. It has been proven safe and has been proven to not have a negative impact. So, I would urge you all to, think of the applicant's initial rights before instead thinking of their, initial inability to do something.
Thank you. Anybody else here to?
Hi, my name is Savannah Smallman. I live at 23 Raymond Road. And when you're a teenager trying to live through a pandemic, these things that the town puts on or what people put on in the town, you look forward to because you could see friends, family, or anyone really. And that's just something that you look forward to. I don't know Tammy, but she put on one heck of a show last year. And I know I was looking forward to a bunch of stuff, but they had to cut it short because of the time, and they have to respect their neighbors and whatnot. But stuff like this brings a town closer, in my opinion, because I know I saw a lot of my friends there last year, and I thought it was a lot of fun. So.
Thank you. Anybody else want to speak to the application? Not, I'll move on to,
I'm Emerald Reed. I've been a resident since 1987. I live at 103 Kelsey Road, and we actually own Emmy's Porta Potties, so this event happening actually benefits us because we provide the portable toilets for the event. So I'm for it.
Hi, Dominic Roche, 85 Town Road, Nottingham. I'm also with the East Watercross Association. We put the show on down in Epping. It's been going on for years. And I'm also with Northwood Snowmobile Club, we've been show since 1973. And Fish and Game supplies the permits and approves it.
I'd like to move into anybody that's opposed. Please come forward. You're more than welcome to speak.
Good evening, Mr. Chair. Mike St. Lawrence, 12 Indian Run. Legal question for the board.
We're not attorneys. We're not attorneys.
Okay. Question for the board's legal attorney for the town. On June 11th, the good governor of New Hampshire rescinded the emergency, or whatever you want to call it, the
Emergency order.
state of emergency order. At that point, the town of Nottingham, then the zoning board, which I assume learned of that, did not have a legal right to conduct a zoning variance meeting by Zoom.
I'm not going to comment on that. This is the planning board, not the zoning board. So unless it's a specific comment to the planning board about this
Sure.
application,
About the application, my question is there a legal right for the planning board to review a zoning that was illegally obtained in a legal meeting?
I'm not going to answer that.
Okay. All right. Understood. I'd like to speak on the pollution concerns and some things that I think haven't been addressed. I guess the question I have is, have we not learned our lessons about pollution from the use of DDT or leaded gas, asbestos, Roundup, talcum powder, lead sinkers? The issues with these has been and will continue to be cumulative. The issue for water pollution and the long-term cumulative effect. It's pretty much why the zoning ordinances in Nottingham specifically limit and ban any new commercial development in sensitive areas. This event is in direct contradiction to this ordinance, and it's in direct contradiction to the master plan and the zoning ordinance for non-conforming businesses in an aquifer zone. In particular, this area is particularly unique and sensitive, as the soil content is extremely porous. The property under review may be one of the most sensitive in all of Nottingham, and the pond that sits 75 feet from a protected Pawtucket River. So the first thing that has not been discussed is that this pond has a natural spring in it, as so described by the owners on the sidewalk. I think this fact may make it evident that the area has a high water table. Second, the pond is surrounded by acres of sand and very porous gravel. This land is one huge sponge. Whatever goes into this sand goes directly into the water table. So the pollution from this proposed event is cumulative. You have hundreds of cars. This is a permanent variance of event after event, year after year. Hundreds of cars will leak gas, oil, transmission fluid, and radiator fluid. Hundreds of competitors will refill their tanks and spill some. Small amounts, but it all adds up. And the gas and oil discharge, the issue is not that the 1 gallon will go into the water, though that can be an issue. They've described that and they have a very good thing. The issue really is that these machines burn anywhere from 15 to 30%. They do not burn 15 to 30% of the gas and oil that's in their engine. So basically they expel a cloud of gas and oil. These fumes don't just disappear. We just think, we don't see them, they disappear. They don't. They're in a plume of gas, and they land on the sand and land on the gravel, and they're absorbed into the water table. So the other question that people always ask is, it's an event on water. Well, however, you look at all the images, there are many times where these motors are on the land. They start on the land, they finish on the land, they warm up on the land. There are all these opportunities for it to be a plume of gas and oil to go into the air, and it just settles on the ground, it goes into the water table. So I guess my issue right now is that not a single person that has anything to do and any expertise in groundwater contamination has been called. This board doesn't have anybody that has told it, and neither has the other previous board for it. So just a few facts about water pollution.
Sir, just to let you know, you have 15 seconds left of your.
Okay. 1 spilled gallon of water, one spilled gallon of gasoline pollutes 750,000 gallons of water. 1 quart of motor oil can pollute 250,000 gallons of drinking water. I urge the board to strongly consider understanding in much more depth about what you're allowing on this sensitive piece of property, and thank you for your time.
Thank you. Anybody else would like to speak against this application? I'll open it up to anybody else who has any comment. I'm sorry, sir, there was someone in the back row that I acknowledged first. And yeah, go ahead.
Hello, I'm Kathy Morris, and I'm in a butter within about 250 feet of the event. When it comes to the noise, you have no idea unless you're there. It is extremely loud and very high decibel amounts. I have a decibel meter. The amount of noise that you get with the regular trucks going in and out stays around 40, 42, and it's just going in and going out, and it's not continually loud. With these machines, while they're racing, it lasts quite a bit of time, and it's one race after another, and it's very loud. It goes up to 85 decibels. Standing outside of my property, I can not even shut the noise out by having all the windows closed. It is so loud, if you're outside, you have to yell to talk to each other. This takes away my enjoyment of the property I live in. People will say, well, she's only a renter. It is still my home, and it's still where I live, and I still have rights to have peace and quiet in my home, as well as the other residents there. They did not come tonight. They were not able to. Also, this event was run last year due to a procedural error with this board approving it before it went to a zoning board, and that was very incorrect.
Let me just stop you there and correct you. It is not, this has not been before this board before. This is the first time that this application has been before this board. It was the board.
They had it before here last year.
Nope. Select board.
It was the select board that did it.
It was the
Authorized
select
it.
board? Well,
Yes, it was.
okay, pardon me, I'm sorry to say that.
Just correcting you.
Didn't realize it, I appreciate that. But it was their procedural error that should never have allowed it to start without going to the zoning board to begin with. And I find it very difficult to listen to people who are in favor of this without them understanding that about being a good neighbor. And this is not being a good neighbor. I've been told I should just take off for a weekend, and that's not necessarily feasible for everybody to go away for a weekend. I've been told that, I just don't like it. It is very difficult for me to listen to without getting a migraine. I get frequent migraines. I've been on medication for migraines for 20 years. There's nothing I can do to stop them. I've tried. But they make me debilitated and unable to function for the amount of time that they are ongoing. The medication I have works partially, but not always really, really well. And I'm sorry if they don't understand that they're not the only ones in the universe that have to listen to this. They listen to it by choice. I listen to it because I don't have a choice. I think that what's good for this town is being a good neighbor to everybody in this town. I understand what they want. This is a unique location for them. But like I said, we're only about 200, 250 feet from the event. We're right on top of it. If they put a barrier, we're still a little bit above that, and the sound will travel upwards as well as it travels outwards. So we don't have any other recourse except to come to you and explain to you how we feel about it. There are other things that I won't discuss here because it's the zoning board that should have taken care of things, but they did not meet their criteria based on the criteria that they said they had.
Could you conclude?
Yes, I will conclude at this point. So I would appreciate people taking into consideration that we have to live with something that is very, very difficult.
Thank you. Anybody else? And I want to just really make this clear. If you want to talk, go outside. I don't want to hear any other talking, whether it's amongst yourselves, when anybody else is speaking here. When there's someone from the public who's here, please show them respect that they show you when you were speaking. Thank you. Anybody else want to talk, speak against the application or anything else?
Quick comment.
Yep.
My name is Steve Reynolds. I'm the president of Northeast Watercross. Excuse me, I don't recall the lady that just spoke her name. She made it apparent that we don't care. That's not the case. We care. I run the entire event. I'm there all weekend long. Last year I ran the light. I don't know if you guys know how racing works, but you hit the light and the racers go. There's 5 sleds right next to me. It's loud. It's annoying. We're not denying that whatsoever. We did, I don't know if you guys received it. I don't know if it was submitted to the planning board. We did do decibel testing and
we haven't received anything.
Okay, well, just to touch on it real quick, the decibel readings that she had commented on matched up with ours. We did extensive decibel testing with like real life simulation testing. It's not unbearable, but like most people say, what's unbearable to you and what's unbearable to somebody else is totally, I mean, that's your opinion. So I respect her opinion, and I understand where she's coming from. I respect what she has to say a lot more than others, fabricating information, exaggerating, or coming up with false accusations and whatnot. These snowmobiles cost upwards of $20,000 to build. You sink them in the water, these things are designed to be sealed up and whatnot. And just to touch on the pollution thing real quick, pollution with watercross is like a hair follicle on your head to just normal snowmobiling in the state of New Hampshire. I have the exact number, I don't know exactly what it was, but I think it was upwards of 43,000 New Hampshire snowmobile registrations last year. Average snowmobile does anywhere from 1,000 to 2,000 miles a year. Hundreds and hundreds and hundreds of thousands and millions of gallons of gasoline. Like, pollution's not the issue. As stated, the New Hampshire Fish and Game comes in and they approve these events. They have divisions that we spend as taxpayers billions of dollars on to protect the wildlife and species and whatnot. This isn't a pond. This isn't Pawtuckaway Lake. They dig from this all day, every day. The only wildlife in that pond, eventually, someday, will go into Jimmy's bucket and to Larry's dump truck and dumped on your property for your new home. It's not a thing. And lastly, on the pollution, I know at least most of us have all been to a boat ramp before. You see a boat back into the water. You see it sit there and turn over and turn over and turn over and turn over and finally sputter, fire up. Boat ramps full of smoke and there's oil rings everywhere. Watercross is pollute. I get you have to protect yourselves and abide by the law, no matter how many kids enjoy it, no matter how many people enjoy it, but if pollution was an issue, if it was an actual issue, it wouldn't be permitted. And so I think the only relevant issue with Watercross was just stated previously. We don't disagree with her whatsoever. It is loud. We've done decibel testing and it's not damaging and it's not unbearable by the, I don't know what standard they call it, by the Health and Human Services or whatever, at her property, at the rear of her property, at the rear of the condos. If you were to be as close to the pond as humanly possible, the highest reading we got, I believe, was 80 decibels, non-harmful. The front of her property was, or not her property, of all the condos was roughly 65 decibels, which not harmful. So just in walking around the front of the building, you drop 20 decibels. So, you know, it's 3 days a year, or 3 weekends a year, I'm sorry. And I'll just close with this, just because I'm a terrible speaker, so I just wrote it down. We aren't denying these events are allowed and going to be a nuisance for some, because that would just be false information and bold-faced lie. For 2021, which because of the way things have gone will now be 2022, next year, I, the series director that creates the rules, will be implementing new sound rules in Watercross to numb it down a little bit. May I note that the town of Nottingham, New Hampshire does not have a sound ordinance. Now, while the town of Nottingham doesn't have a sound ordinance, I'm not saying it shouldn't be observed, because in all honesty, it's part of life. You gotta respect the town and represent the town. We also aren't denying some will like it and some won't. In this country of ours, there are enormous events like the Epping Grass Drags where 40,000 people come from all over the country to attend. 4th of July fireworks, fairs, carnivals, concerts, protests, weddings, and so on. There will always be an inconvenience to somebody. We don't all like the same things. Somebody's not gonna like it. So we're not saying that we don't care about her opinion or it's not loud or whatever. It's just some things in life you don't like. I mean, that's how you were raised. Your parents told you don't like it, like, too bad, suck it up. Like, it's not too bad, suck it up. It's just, there will always be inconvenience to some. But when the convenience is far greater to far more than the inconvenience is to such few, part of the freedoms of living in this country is to allow such events to be enjoyed by many while boosting the economy. So kind of like the people that have spoken before us, like, you know, that's the great thing about living in this country is the freedoms to enjoy life. Where if you just take away everything, you take away everything fun, it's just not realistic. That's not life. That's not the American way. As a couple people stated, we did do this event 3 times last year. There was no inconvenience whatsoever aside from the sound, which is duly noted, and we do our best to work on it. But after testing, it's proven that anything, and just so you know.
If you can just kind of finish that. So.
Yeah, so with the testing, beyond the condos and whatnot, everything else was diminished so much that it was just not even, you know, there's more to it. But anyways, that's basically all I was going to say.
Okay,
Right.
appreciate it, thank you.
No, I appreciate you guys and thank you for, and also, sorry, every single time that we come before any board, we're always brought back. We keep coming back and keep coming back. And as the gentleman spoke before, it seems like if we stay on this track, we're never going to get anywhere. So I was wondering if there's any way, shape, or form. You know, when I was going to school, the teacher gave me a checklist. I did everything on my checklist, and I got the reward. I don't know if there's a way that we can come up with this is exactly what we need to stop. I think Tammy will agree. I don't think we want to come back until we have everything that you guys have to make a decision. Because if we keep doing this, we're never, ever going to finish this. And quite honestly, like, we'll all end up broke. And so it's just curious if there's a way that the board can get their heads together and, you know, say this is A, B, C, D, E, and we'll go through and we'll answer it. It's just always like, hey, could you guys do these 3 things? We come before you with the 3 things and like, actually, you know, could you do these 3 things? Could you
Well, I'm going to have to interrupt you because there's a lot of information that has been requested that we've not received. So, you know, this is a 2-way street, right? So we need some information so that we can form our opinions to make decisions. And if we don't have the information, we can't make those decisions. So there's some information that's pretty critical. And to be honest, we have not had a watercross event in this town ever. There isn't a checklist for a watercross event. So we have to go between the lines a little bit and interpret. So that's what we're trying to do.
Yep.
And yes, it's probably a longer process than if you were to do a subdivision. So, but there is a process that is in place. And it's by state statute that we have to do these things.
I'm not saying not to do them. I'm just asking if there's a way that we could get, you know, instead of, I mean, we've made comments on, could you get this, could you get that, could you get this? And then we come back and a couple things were like, there's no like actual requests from the planning, formal requests from the planning board asking for the things that they need so we can actually make sure.
We have provided the applicant numerous comments from either the planning board, the building inspector, planning board representatives. There's a lot of comments that are out there that have not been responded to. So that's why we're saying, if we can get those responses, then we can move forward. That's why we're not able to have all that information in front of us.
Do you know exactly what?
Yeah, I know, I
Okay.
do know.
All right.
So you're,
That's all.
yeah, thank you. And I don't want to, this is part of the public hearing, so I want to make sure we continue the public hearing part. Anybody else want to speak to this application, for or against? Okay, I'll bring it back to the board at this point. I don't think we have enough information. And it will have to consult with, potentially consult with legal attorney to see on whether the circuitous.
Do we need to should we
Zoning.
vote on that as a board if we think, or just because we just want to go that route?
We can vote on it if you'd like. Anybody can make a motion.
We have gone that route before, so it's again, not trying to necessarily do it. It's, you know, there was, I'm thinking the subdivision on Gile Road just earlier this year, or it might have been last year at this point. You know, they went to zoning for driveways, but they didn't go for the wetlands impact, so they had to go back to zoning. And that wasn't because, you know, we wanted them to, or we wanted to delay it, but it's because there was a separate part of the zoning ordinance that.
Well, I agree with that, but I also think that this overlay specifically refers to the underlying district, which that's what they're essentially, it's one thing sitting on top of the other, and that's where they play off of each other, so. I don't know if we need to make a motion or vote on it, but just worry about the timeline if it's a separate timeline. I don't know how fast town council gets back to us on comments usually.
You know, if any board member can make a motion for whatever vote, it's a second that needs to get there and then the votes to have it. So if somebody wants to make a vote, we have options. We can either vote to accept, or vote to approve, vote to deny. We have allowed to continue. So there's options that
How
we
much
can for
information
this.
is it that Tammy has or needs for us to make a decision, or that you were looking for? I mean, this is my first time at the board, I mean,
There's a lot of things that are not on the plan, that need to be on the plan for us to be comfortable with it.
And she has a
being
list of all that stuff,
Yes.
right?
We have a
Yes.
plan of review in the.
We just got it on the 12th.
And we have no problem putting that stuff on the plan.
Mr. Chairman, I'm gonna make the motion, because again, it's been my history. Again, I don't like to potentially outstep our bounds as a board, and I always think it's better to err on that side of caution. And if we're continuing a case, I don't see it as harmful to ask for town council to weigh in and guide us, you know, as either accurate or not accurate, and we will usually respond to the applicant with that information too. So, I move that we get legal counsel advice on whether or not the prior granted variance covers the underlying aquifer overlay district requirements, or if a separate variance would be required.
Is a motion, is there a second?
I'll second, but I'll make a suggestion. And any other item that legal thinks might be an issue. Separate issue.
They don't work like that.
They don't, we
No,
need.
we have to ask them
Premature.
specific questions of what we would like to see.
And I went through, you know, some of the other districts that I thought potentially could cause, like, you know, a problem and make you have to go to zoning for it.
Well,
And
can
I
we
don't
deal with
s-
can we deal with the motion?
No, I'm saying I don't see any, so I'm trying to say, to Stu's point of, you know, trying to make sure we get it cleared up, like the wetland conservation areas, I don't see it being in that. Special flood hazard areas, things like that, I don't see that that those zones or anything else would require, you know, a separate variance or anything for it. So I was just trying to speak.
I don't understand your point.
Trying to say, I don't see any other items in our zoning ordinance that would specifically require relief that hasn't been granted, except for the Aquifer Protection District language.
So I withdraw my suggestion.
Okay.
I'm okay.
So is there a second?
Sue seconded.
Sue second. Okay, I'll roll call vote. Ian?
No.
Sue?
Yes.
Buzz?
Yes.
Yes.
No.
Yes. And I'll vote no.
So it passes?
So it passes. So we'll get legal advice on that. And
And that's at no cost to the applicant, correct?
Correct.
Are you ready for another motion?
Yes, ready for another motion.
Well, I guess my first question to the applicant, with the 4 comment letters, the technical review, the fire department, SRPC, and then if you make a brief mention of the Conservation Commission recommendations, since it's under the planning board, what's the timeline? The next meeting's the 28th. I don't know if we're gonna receive legal counsel by then, but is your intent, you'd like to shoot for the 28th?
I'd like to probably go for a month, because if we do the 28th, it's gonna be Monday.
Right, you need plans back in the next couple
We're not gonna get a
days.
comprehensive plan together by then. I'd like to submit it comprehensive, so we're ready for
That's the
approval
11th.
at the next meeting.
So the August 11th, did you think? August 11th meeting is the first meeting in August.
So the applicant wants to submit for Monday.
I just want to know what date to include in a motion. If you want me to put you on the 28th, you can always.
28th.
Okay.
We can work with you on when that material can get to us. I mean, obviously would like to get it as soon as possible, but, you know, it doesn't have to be a week prior.
I think we have all the material. I'd just like to put it in a comprehensive package, so there's no question.
I think my opinion too is if they can get to us as soon as possible, they can walk through, even take the time to walk through every comment and show us where it is on the plan, if that's what it takes.
Yeah, I mean, we'll work with you in trying to clean up, make sure that every comment is at least addressed, so we're walking in with our. Yeah.
So I'll make a motion to continue case number 21-003-SIT to the July 28th meeting. Does that work? To the July 28th meeting with responses and plan edits related to the various comment letters.
At 7 o'clock.
At 7 o'clock on July 28th.
Motion.
Second?
Motion and a second. Those in favor indicate aye.
Aye.
All those opposed?
And as always, if something happens and the deliverables aren't available, you obviously can just request a continuance and we get on to the next available meeting.
As soon as you get the legal counsel back, will we be notified of something?
I think Dirk usually forwards it. That's
why you came.
Thank you. Thank
Yeah.
you.
Okay, let's get through what we have left, which are minutes. If you guys could take the conversations outside, we still have some business, thanks.
Shall I make comments
Just
about
keep
the
them.
minutes?
I didn't know she needed that
When
back.
you're ready?
No, she said they're ours.
This one?
Those are pictures. She probably has them on
No,
file.
this was the.
Yeah, I think she's gonna be sending us some of the stuff electronically.
Okay, can I have that, the hard copy of whatever?
Yes.
that
Whatever
we
that is.
don't have? Do they have this? You have the DOT packet?
I'll give this, there's a couple,
Okay.
do you have the thing, like, there's a fish and game permit in here? You have that?
That's in there.
Okay, I haven't, all right, I haven't,
Handed us some stuff we already had.
all right. Yeah, I know they have the appraisal stuff. This is all stuff that's online.
Yeah.
I've seen everything
But it
else.
came as a whole.
Yeah, I think it was, these are the 2 appraisal documents. I did see the LRAC comments.
We don't have the fishing game.
So that one is in here.
Just, how about just give her the whole thing?
Yeah, yep, it's like in the middle of that, I think, or the front half.
Right, just put that entire thing right.
Some of it, a lot of that's repeat, but.
Yeah.
Okay.
Minutes,
May I speak?
please.
Sir, I reviewed the minutes that Jen sent along yesterday, and March 24th, May 26th, and June 9 look wonderful.
So is that a motion?
No? I also reviewed May 12th and June 23rd. There were just a few more edits. They were either grammar, punctuation, capitalization, a verb in noun agreement. There was no substantial suggestions.
So as corrected?
So as corrected. So I move that we accept the minutes of March 24th, May 26th, June 9, May 12th, and June 23rd as edited.
Second.
Motion is second. Before, Does that include the site walk?
Sidewalk was already approved.
Okay.
We approved that like
Oh,
a
that's
month and a
right.
half ago.
Yeah, that's right.
No, I didn't know if it was, that's why.
I think
I
we
just
did,
saw
that
it
was,
as a draft.
that was one that I think we,
No, we accepted it. You don't have an official copy?
But it was
I
approved.
do recall,
But it was accepted, though.
Right, I remember the sidewalk being accepted, I just,
Want me
we
to,
weren't working on minutes at the time.
Yeah.
you want me to send you my copy?
No, as long as Chris has them, we're all.
Those in favor? Indicate
Aye. Are we adjourning? Or the minutes?
unless, staff updates, the only thing I just want to throw out there is I actually won't be in the state on the 28th, so I won't be at the 28th, but this will be my first meeting missed, so it's a sad day.
We're sorry.
That's all I got.
Anybody else just want to chime in with anything? Because I don't want to go around the room.
Something really quick. Back first. I'm not shy. Pete Landry, an applicant to be, came to the Conservation Commission meeting on Monday because they wanted to do a backlot subdivision on Mitchell Road. So we reviewed the whole application, knowing that it would come to us anyway. So as soon as we have a case number, we will write up our review and send it to the planning board. And you may review it whenever you wish.
So you won't give it to us the day before the hearing?
Probably not.
You'll have it before, okay, good.
You know, the time was an issue with this particular letter, and that was on.
All right, we're adjourned. Thank you, everybody.
Thank you.